You may have recently heard about this UK Supreme Court decision. It's been described as the case that defines what a woman is, but that's not quite right. What this case actually dealt with was how the courts should interpret the Parliament's use of the word woman in a very specific context, the UK's Equality Act of 2010. But this has concerning ramifications of the rights against discrimination of trans people regardless. Now, while this case has no direct legal effect in Australia, the results of this case are still concerning. Some of our legislation, namely the Sex Discrimination Act of 1984, similarly separately defines gender identity, intersex status, and sex, while taking a primarily sex-first based approach to many of the exceptions to discrimination. This also applies to a lesser extent to Victoria's Equal Opportunity Act. But Australia has a proud history of upholding the rights of trans people within the courts. However, much of this has been limited to the lower courts, something that was similarly the case in the UK until recently. Australia's legal system is based on the same foundations as the UK's. Our courts use similar methods to interpret laws, especially when those laws are unclear. And if there's ambiguity in the way our legislation protects queer people, as we believe there is, courts here could reach similarly harmful conclusions. Right now, the Liberal Party is quietly opposing trans and queer rights, and Labor recently removed explicit protections for LGBTQ+ people from its national policy platform. We must hold our parliaments accountable. The Australian Democrats have a proud history of standing up for LGBTQ+ rights, from pushing for law reform to being one of the first parties to push for marriage equality. We've always believed in dignity, inclusion, and equity before the law. That legacy matters now more than ever.
Authorised by Acre Street, Australian Democrats, Nairn.